Call this meeting to order. Please rise for the Pledge of Allegiance.
Allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. We have the minutes from the January 5th Planning Board meeting. Public hearing on Camp Rama, Phyla lot line change. Then we had a resolution to grant approval for the Camp Rama lot line alteration, which was approved. And then we adjourned the meeting. Motion to accept the minutes made by Member Sador, seconded by Member Palmer. Discussion? Seeing no discussion, all those in favor of accepting the minutes say aye.
Aye.
Any opposed say no. Okay, that passes 5-0 with one absence. All right. Next, under old business, we have Wingdale Solar. If a representative from Wingdale Solar, please come to the podium. Thank you, Member Palmer. All right.
Good evening, Mr. Chairman, members of the board. Thank you again for having me. My name is Tom Saunders. I am representing the applicant, Wingdale Solar, on behalf of Rick Energy. Since we were last here in December, we have submitted a draft FEAF Part 3 as we discussed at the last meeting. So that just consists of the actual draft FEAF Part 3 filled out to the way we believe it should be. And along with that, we submitted a narrative letter that we hope would guide the completion of that Part 3 as well. Basically, the letter touches on the items that were marked as moderate to large impact on the AFEF Part 2, which we went over at the last meeting in December. So that's really all the new materials that we've submitted since the last meeting. I wanted to also mention that at a previous meeting, we said we would put up a project-specific website, which would basically just have my contact info, all the information that's been submitted to date, information on past meetings, information on future meetings, and serve as kind of a touch point for any members of the community who want to stay up to date on the application. And we do have that website up. I have a printed QR code here. I'll put it out on a chair here. If anyone wants to scan it, it will take you right to the website. I'll also email a PDF of this QR code to the town, so it's here for distribution. For anyone who might be watching, I'll read out the URL. It's a little long and convoluted, my apologies, but just to make sure people can access it, it's sorry, let me make sure I wrote this correctly. It is https://northamerica.ric.energy/projects/Wingdale-solar, which I know is a mouthful, but again, for people in the room here, you can scan this code and it'll take you right there. And so I'll go put this right here. We are in receipt of the memo from AKRF. Thank you for that. And with that, I will stop there.
Okay, thank you. I'm just doing a search. Came across your website.
Yeah, it's probably not very searchable.
Yes, it keeps coming up with other projects, even
Yeah,
though it
yeah.
says Wingdale PV
Yep.
LLC solar project. Okay. All right, well, we don't need to muddle around with that. Okay, so you had sent along what you thought was how you thought the FEAF Part 3 should be, and this project will result in no significant adverse impacts. So let's discuss this. I know AKRF had prepared a memo.
Sure. So the just to start, the part 3 of the full EAF is for the board to complete, not
Yes.
the applicant. I mean, it's appreciate that they submitted a draft, but it's ultimately your document to issue. I think what we talked about at the last meeting was that rather than them preparing a part 3, like the form itself, we were looking for more of like a narrative responding on each of the questions in the part 2, elaborating, maybe providing some additional analysis as to why the impacts aren't as moderate to large as they might potentially be. So I was under the impression we were going to see some additional visual rendering, some more work from like the Highview neighborhood. But we just got that letter. So, you know, my approach for this meeting was just to prepare this memo to just kind of summarize where things have been to this point. I think we're at somewhat of a crossroads here now. We have a part 2 with some potential identified impacts in it, mainly visual, noise, consistency with zoning. The board has 2 options. There's, you know, a negative declaration would mean that none of these impacts are significant. It ends the environmental review. It would allow the zoning board to act on the variance requests from the applicant. The other option is a positive declaration, which would focus on a couple of areas, and it would start an environmental impact statement process, which includes a scoping meeting for the public to participate in, to nail down exactly how these potential impacts can be assessed in an environmental impact statement. I'm not recommending either way at this point. I mean, I think this memo is pretty clear where your decision-making lies. And if you so see it, your consultants could prepare a positive declaration for review at the next meeting that focuses on the impacts that you've identified as potentially moderate to large from the part 2. And that would start a process by where the applicant would submit a draft scope of work for an EIS. We would review that. There would be prescribed timelines where we would have to adopt that. There would be a meeting where the public can weigh in on it and offer comments. We would offer comments. And then the applicant would be off to draft a draft EIS. So that's where we are. We can go back through the part 2 again. We could, you know, we did do kind of workshop it last time, and we made some edits. But I think we're at a point where it might be best to make that decision so that we can have a firm, you know, path forward based on the guidance that the seeker guidance provides for an EIS, which I think is pretty protective of the applicant and the town, honestly, going forward. So that's where we can go
All
from.
right, so let me just read from the AKRF memo, because I think in one sentence, it basically summarizes the meeting from about 6 or 7 weeks ago. At its December 15, 2025 meeting, the planning board began deliberating on a draft of the project's full environmental assessment form, or FEAF Part 2, wherein based on several factors, including its size, potential visibility, and nonconformance with zoning requirements, at least one analysis area was determined to have the potential to result in moderate to large impacts with respect to the environment. That's what happened, right?
Okay.
So the response that we got from you or your, organization was, here's a form for you to sign, Mr. Chairman, we don't think there's a problem. Does that sum it up, or?
Certainly not our intent. We
Okay.
understand that the board prepares the form. We just
Right.
heard submit a draft part 3, so that's what we did.
Okay. Now, what I remember hearing, and I think Planner Werner got to this, was what we thought you were going to do was say, here's evidence as to why the board might not be looking at this the way we think the board should be looking at this. Did you submit anything else besides this form that just says there's no significant adverse impact, or?
Yes, we did submit a letter along with this form
All right,
that has
let's go over that.
the narrative content that I think probably you were getting at.
Secretary Van Millen.
Go on,
before this-
yeah, they upgraded my computer and I lost some stuff and I was,
Okay.
uh,
So where would I find it? Might it have been put back here, or
there it is,
this?
yeah.
So this is what we received on the day of the,
Oh,
Right.
maybe
No,
that's-
there was another letter dated February 6th that we submitted
February
with the
6th.
draft FEAF Part 3.
It's the future.
And I'm not actually sure why it's dated February 6th. That's a typo. I think it probably should be January 6th.
Happens to the best of us.
would you like your laptop?
Yeah, let
to
me
find?
see if
Maybe
I
it's in your
can
email.
bring it up from the emails.
Okay.
It's in the
Scott
113
was in the
submission.
transition.
It came around that date. I don't know if that helps.
Came in on January 13th.
Yeah.
This one? This one?
Sorry.
That one. From the 13th.
Thank you, Mary.
Okay. Thank you. Okay. All right, so you did provide some pushback as to what the board is thinking with respect to your project. And your conclusion is based on the full environmental record, including the FEAF, visual impact analysis, acoustic assessment, supporting studies. The project does not present the potential for one or more significant adverse environmental impacts. And you go on from there. So. Okay. So we see your memo now, and Attorney Polidoro, if you just go through with the board what our options are at this juncture.
Sure. So you have a draft part 2 that we went through at the December meeting. There were a few questions where you indicated that the board thought there was a potential significant adverse impact.
Mhm.
There's also a question that Valerie was going to look into more on the historic resources. So we should go back through some of those questions, see if the information provided changes what the board initially thought when they went through that checklist. And if not, we can decide whether you want to move toward a pause deck, which would have them provide additional information and studies, or a neg deck, which says that the environmental review is over. If you expect the likelihood of at least one significant impact and it hasn't been mitigated as part of this project review, then the pause deck is appropriate.
Okay.
And it only takes one potential impact.
Right.
And the planning board doesn't have to prove through a positive declaration that there is one, a significant impact. It has to be studied further, is what you're saying.
Right. That there's a potential for an impact.
Correct.
That there is an impact. Okay.
And I should also add, sorry, that, an EIS, again, should you go that way, requires a study of alternatives, right, where we would have to come up with some alternatives through the scoping to, alternatives to the proposed action, maybe, I'm just throwing it out there, a version that has, more zoning compliance, or the larger setback adjacent to the residences on Highview compared to other parts of the site. Things like that. They can study alternatives and compare those to the proposed project to see if their impacts are reduced.
All right, so looking at this, I would think consistency with zoning regulations would be one area that would be of moderate to large potential impact. While you rightly state that it's allowed in the RU zoning district, it's not allowed in the current configuration size that you have proposed. So while you say the project remains consistent with the town's solar energy law, that doesn't seem to be the case, because it's not. You need to have 6 or 7 variances from the ZBA in order to complete your project.
Yeah, I mean, I think, again, our position on that is spelled out in the letter. The project does require area variances. We're certainly not disputing that. We're in front of the zoning board currently. That public hearing remains open.
Okay.
However, solar is an allowed use in the RU zoning district. So with the exception of, yes, the area variance is required, the remainder of the project is compliant with the town solar energy law. And I think our point is that with regard to seeker, like as we stated, the issuance of a positive declaration based solely on the need for area variances is not really spelled out in the seeker regulations, as far as we can tell.
Well,
Mayor Valadero?
question 17, which is the question we're talking about, consistency with community plans. It asks whether the proposed actions, land use components may be different from or in sharp contrast to the current surrounding land use patterns, and then it gives you the option of no or small or moderate to large. So that is one area where you indicated moderate to large. And the second is proposed action is inconsistent with local land use plans or zoning regulations. So that is a direct question from the EAF, and so seeker is asking you to evaluate the consistency with the zoning regulations. And I can pull up the handbook as well, and we can talk through that question if you want more guidance. But I don't think it's accurate to say that seeker doesn't consider the need for variances, because
Right.
that's exactly what that question is asking for.
Yeah, I think our contention there is that's understood, and I think we're just disagreeing on the magnitude of that. I think it would be a different story if the project required a use variance, right? That's kind of a different standard. It's a different animal. One of the area variances happens to be the minimum lot size, where something like 2 acres under that, I mean, that's really pretty close. Understood that there's some feeling amongst members of the town and members of the community, certainly potentially members of the zoning board, that the area variances as they relate to the setback specifically are significant, right? Because you have a 300-foot setback. We're asking to reduce in some cases to closer to 170 feet. I think where we come at that from is we understand that that means, okay, the variance that we're asking for in front of the zoning board is almost 50%. There are uses that are allowed in this district that have setbacks as low as 30 feet. So not saying that that's what the solar law should be, we're just coming at that saying, okay, there are uses that could be built on this piece of land that are arguably more intense than what we're proposing as far as, the way they alter the landscape, and those setbacks can be as low as 30 feet.
Attorney Polidoro, is this the document you're looking?
Oh yeah, that's the handbook. I was in the workbook right now,
Workbooks?
but here, I'll read the workbook.
So should I find the workbook?
Yeah, you can find the full EAF workbook.
Yeah.
It says, under this question, a moderate to large impact could occur if the proposed project is not consistent in its proposed use, dimensions of the lot, dimensions and locations of all structures, setbacks, size of structures, accessory uses, and overall scale and intensity with existing land uses and local laws, and plans encourage maintenance of such existing uses. So, if
What page would that be on?
I'm at, oh gosh,
Is
it's
this Is this document?
yeah, I'm not in a PDF of it.
Okay.
Maybe you can word search Q17.
Is it Q.17? 17.
So you want to go to the Part 2 section, and then it goes through each, there we go. Question 17.
Okay, so we could just go through that again?
So I was reading the sub-question, but the sub-question was about consistency with the plans and does it comply with the dimensional regulations. And so here, it's always a balancing test. It's never black and white. But you have a newly adopted solar law, which set forth the community's vision for how it sees these types of uses with certain protections to ensure that the residential uses can continue to be maintained. And so that's what you have to decide, whether it exceeds those standards so much that it's going to result in an impact. So if you go down just a little more, yeah, keep
A,
going.
B.
Keep going.
C, right?
It's the C, so it's that one. Stop.
Oh, might be.
Okay,
Keep
keep going.
going. The next light green box. Right
There you go.
Yep.
The proposed action is inconsistent with local use,
Yes, that
land
one.
use plans, or zoning regulations. Okay.
Yeah, so that's the section that the board should read. I don't know if you want to take a minute for everyone to read it.
Okay.
So the top of that bottom page is relevant.
Right. So if zoning exists, an action would be considered consistent if it is a permitted use or a specially permitted use and meets all zoning requirements for that use and district.
However,
However, if the project requires a zoning change or an area or use variance or is in conflict with the stated vision, goals, recommendations, or land use concept map of a comprehensive plan, then the proposed action is inconsistent, and the reviewing agency will need to evaluate whether this inconsistency is small or moderate to large.
right, so you've identified that it's inconsistent, and now it's up to you to balance that, to decide whether it's potentially large, potentially small.
Okay. And that's one of more than a few concerns that was raised at the meeting in December. Okay. Member Robert, you had something to add on a historic basis, was it?
Oh, yeah. Well, I wanted, I was concerned about number 10, and I just wanted to refresh my memory by looking at the historic survey because we had stated that the proposed action may have on number 10, impact on historic and archaeological resources. It was checked no. And I don't think we should just automatically say no because it is a historic district. There were at one time many historic buildings there, and there still is the First Baptist Church. At one time, that was the only church at all in Dutchess County, or in our area anyway.
And that would be, if this road, if 55 continues a little further here, that would be approximately
Yeah, it's on the
there.
next page, I think.
I know.
Oh.
So how,
Go back.
can you give me an idea of how
Yes.
close or far these are?
There we go. Okay, there it is.
So the Baptist church is there, also the firehouse, the Wingdale Firehouse was the carriage house of the Wing estate.
Out here.
And so there is, and then also, it's very close to, we've got the intersection that we're considering our gateway is where it comes in from Connecticut, and then it goes over to, up over Wingdale Mountain. It's in that whole area, so I don't think we should automatically say that it's definitely no impact. And the only thing I'm concerned about is it seems like the one thing that would definitely or probably at least help to mitigate it would be keeping strictly to the setbacks and to the buffers. And the setbacks and the buffers are already applied for a waiver. So, I mean, maybe it could still be solved, maybe it could still not be an interference, but I think we have to look at it and, realistically and decide whether it is or not.
So can you give us a little more information on why is the First Baptist Church recognized as a locally significant historic resource? And do you have any information on it you can share?
It is on the historic, it is on the Dutchess County Parcel Access Historic Survey, and so are the buildings that were there that are gone. I have a copy if you want.
The state has indicated that it's not going to impact any state-listed resource, but there's an opportunity under subsection D for you to identify other impacts, and you can flesh that out for locally important resources, and that would be where we'd want to list these locally significant resources.
I think the historic markers for the Morehouse Tavern and for the Clove Road Camp on Pleasant Ridge Road, those are federal and state recognized markers. So I don't know if it's just Dutchess County.
But those, okay, so there's markers there, but the markers are marking something that's not there any longer, and then there's a church which is historic, and if you could provide some more information for the record on that, that'd be helpful.
The church is still there.
Yes.
Yeah.
But
So
it,
that
yeah.
doesn't need to be provided at this moment.
No, just as we move forward. So we can mark that in that section as a locally significant historic resource.
Okay.
And then if the board wants, they can change discuss changing that answer.
Yeah, I think it would be, you would change 10, the main question, to yes, and then no for the first 4 or 3, and then for D, other, you could put locally significant, potentially locally significant landmarks.
Mm-hmm.
But we do have a letter from State Historic Preservation Office that looked at the site for archaeology and structures, and they issued a no effect letter for the project. So that's what's been used to answer the first 3. of that question. They didn't see any concerns with anything proximate to this, and they didn't see anything on site, so.
Right, regarding state and federal listed resources. Valerie, what were the other two? Something wing?
The firehouse is the
Jackson Wings.
Jackson Wings Inn.
part of Jackson Wings estate. I think they did pick it up and move it a little bit back when they made it into a firehouse.
Yes, that used to be much closer to the roadway.
Yeah.
But as you can see, Jackson Wings Inn is like a twin building to Old Drovers. It's got the same architecture.
I mean, it made it onto the blanket from the bicentennial. So.
Unfortunately, it's no longer there. It has been
No, I'm saying the Waydale Firehouse.
torn
Made it
down.
onto
Oh, the
made-
firehouse?
Yeah, made it onto the blanket.
It did? Oh, that's good.
So is the Dover First Baptist Church in the bottom left corner.
Okay.
Okay. Anything else you wanted to discuss with respect to this right now?
No.
Okay. All right, thank you. Member Villano,
No comments at this time.
thank you. Member
No comment.
Storr, Member Williams.
comment.
Okay. Just to kind of cover everything, Engineer Berger, anything on your end to discuss?
Well, the only concern I have, and we pointed it out before, was for them to follow up on the stormwater, which is studied and shown that there's no increase or impact on stormwater as it leaves its site, but did not discuss the impact on Route 55 itself.
Right.
And we wanted some further information on how the water runoff as it comes down the site through that stream and goes, the capacity and the ability for Route 55 to handle that. And that's all we wanted. And that may or may not rise to the level as the board looks at as small to moderate, but it's something
Right.
that should be looked into, whichever decision you make.
Planner Warner, did you want to add anything else?
Well, on the stormwater issue, I think the places to look are the questions that fall under 1, impact on land, and 3, impacts on surface water, because there's several questions in each that deal with that. I think it might be the one under 1, F, increase erosion, whether from physical disturbance or vegetation removal. And then under 3 for surface water, I mean, for number 3, it really focuses on stormwater discharge to surface waters, not Route 55. So I don't know if it's really belongs there, but, because there's not a receiving water body that we're talking about. We're talking about flow down to another impervious surface.
Right.
So it's probably an impact on land question under number 1.
Okay.
And then just,
Yeah, again, we're not saying that there is an impact. There wasn't sufficient information within the stormwater report to say yes or no.
Right.
The study was done just based on what the state requires for stormwater permit, and the state did not require that level of analysis. But we feel that it should be looked at.
Right. Thank you.
and even if there's been, prior studies on certain topics that we've got the record on, if you move forward with a positive declaration, there's no harm in having those repackaged into an EIS type of format. It's been done before. It's common. Again, it's creating a record, and it's focusing on those areas that you're concerned with. And, I'm seeing this, if it does go that way, it's what we would call a targeted environmental impact statement. It's covering a few things. It's not covering the entire 18 categories of the Part 2. is very much focused. And if that means having to recycle some of the stuff that's been presented to you already, in pieces or otherwise, that's totally okay. Again, it's your call to make, so.
Okay. Thank you both. And Attorney Valletta, do you want to add anything else? I mean, you already spoke. but-
No.
Okay. All right, so we still have in front of us this part 2. The only thing I've heard from a board member tonight was about reconsidering number 10. Before we get to that, is there any board members who want to look at reconsidering any other parts of this part 2? Member Williams? No?
Nope.
Fedor? Marvellano? Okay. Member Lorberdier, was there anything other than number 10 that you wanted to look at further? Or?
No. I don't
Okay.
think so.
All right, so proposed action may occur in or adjacent to a historic or archaeological resource.
Well, the only thing is, it isn't consistent. Well, if it's going to be visible from the gateway, I mean, I thought the comprehensive plan said that the gateway area was supposed to be enhanced. So I don't know if it's even going to be visible from that,
Right.
but we should look at that.
The gateway and comprehensive plan question can go down into 17 when we talk about community plans.
Okay.
The gateway,
All right, you already have yes on that, so that's okay.
we have that as a yes, but we can add H other, and we can specifically identify that as a potential issue, so, we know to look into that.
That wouldn't be covered by letter C. The proposed action is inconsistent with local land use plans or zoning regulations.
Yeah, it
Yes.
is covered there. I'm just saying for other, we could specifically call out the district if you want, or we can add that to the narrative statement that will be prepared as you move forward.
Okay. All right. And then, so just, I guess my question I have for number 10, the proposed action may occur in or adjacent to a historic archaeological resource. So it's not, we're not saying it may occur in a historic or archaeological resource. We're saying
Adjacent.
potentially adjacent. But how adjacent is adjacent?
I mean, adjacent is next to, across the street from even Caddy Corner.
Uh-huh.
I couldn't tell from that map
Okay.
how,
All right.
Well, I could not look at the plan online because the banner takes up most of the screen. And the
Okay.
part that you can see of the plan is real tiny. So I really couldn't tell if it was right next to the church or what.
Well, I think what might be in the way of it being adjacent is a number of homes that are on Highview Drive.
It's across from the church.
So let me just get over to there. Zoom in. That's the wrong Highview. Okay, here we go. All right, so this is the project parcel. I'm thinking this is the church. Yeah, Dover First Baptist Church. Is this what you see here in yellow?
So it's
So that's
prob-
there.
mhm.
This is here.
Is it the one right
so
above
it'd
it,
just
too?
be the tiniest part that would pass.
And everything here would be
Gateway.
right. So these would be.
Okay.
This is a home that's on Route 55. This home is either on Route 55 or on Highview, and then all these other homes are on Highview.
What about that one right there?
It would only
Which one?
be,
Run right here where it says 55.
Only thing that
That
would
is the
be
Dover auto body.
approaching on the gateway would be the part on 22,
Mhm.
as you head towards that intersection then,
Part on 22 over here.
yeah.
Okay.
But the other side that I was looking at, it looks like it would be just the tiniest
Right.
little piece. You probably wouldn't even see it.
Yeah, this would be where the firehouse property
Firehouse.
is located.
Oh, you were looking at the cemetery.
Here's the school. What?
These two. Because if that's Dogwood Auto Body,
Mm-hmm. That's a house. That's a house. That's a house. The cemetery's here.
yeah, no, I thought,
So this is the church.
Substantially contiguous is kind of the word.
Cemetery.
I know.
So that's why I just asked the question about how adjacent does adjacent need to be.
I mean, the word is substantially contiguous, and I'm
Right.
scrolling looking for some words. The
That's
phrase.
That's what
phrase.
the seeker guidance says, yeah.
So if they were proposing it here, because the church is there,
Yeah.
Yes,
that would be-
absolutely.
And you're,
adjacent.
honestly, there would have been a chance that OPRHP's letter would have acknowledged that or looked at that too.
If it was actually, so adjacent has to be actually next to.
But substantially contiguous, and it's
Okay.
in the discretion of the board, but maybe, one parcel away,
Mm-hmm.
catty corner,
Right.
visible. Here, if you stand there, I'm not sure that they see each other.
Yeah, I don't believe that they would.
Brian,
It's a contextual
see what that one is?
thing.
Yeah.
That would
Are there going to
another
be
church.
contextual impacts?
Methodist
Oh,
church
well,
parking
that's fine.
area, and then the
Church is confused.
and then this is the Methodist church itself,
Gotcha.
which I don't know if the Methodist church is historic.
Is it on
It's
the
on the
blanket?
blanket, but I don't know if it's historic.
I honestly don't know what I thought we were talking about.
No, no, this is the one where as you're driving towards Connecticut, as you basically start to go downhill, it's on your left.
I guess.
Sometimes they
Gotcha.
have like pithy sayings.
Yes.
Yep.
Okay. So I guess back to the matter at hand with respect to this document, which is now lost in a sea of other documents. There we go. Proposed action may occur in or adjacent to a historic archaeological resource. I mean, I think we have to say no. There are historical resources nearby, but based on what seeker says, we can't say, I don't believe we can say yes, but it's not up to me, it's up to us, so.
And just for the record, I'm on the SHPO's CRIS database, the Cultural Resource Information System. And it shows for the church, for example, First Baptist Church, they have a status of undetermined for that building. So they don't have a stake in it. They're not identifying it as a state or national or federally listed or eligible
Right.
property. But if it's local, sure. But if it's not substantially contiguous and not going to be contextually affected by the solar panels.
And also,
then-
I mean, my understanding is that buildings can be considered by the broad public as historic, but if they don't actually apply to be historic,
Correct.
then the government doesn't see them as historic. And some buildings don't want to apply to be historic because then potentially comes with a lot of
They
restrictions.
don't want to be regulated.
Yeah.
Yeah.
So while we all might agree that it's historic, if they don't apply for that, then in the eyes of the higher government levels than us, it doesn't count. Okay, so I think for now we'll keep this as a.
Okay.
All right. Anything further on this document? I'm not hearing that anyone wants to change anything.
No.
Okay. So based on not hearing that anyone on the board wants anything changed in this document, and based on that the document has a number of yeses that also then includes moderate to large impacts may occur, I believe it's prudent that the planning board would ask our consultants to prepare a positive declaration. But like I said, this is not up to me, this is up to us. So, discussion,
I
I happen to agree.
agree.
agree,
Agree.
agree, agree. All right, so that needs to then be now a formal motion. Motion made by
So
Member
moved.
Villano, seconded by
Second.
Member Sador. Any further discussion? Seeing no further discussion, all those in favor say aye.
Aye.
Aye. Any opposed say no. Okay, that vote passes 5-0 with one,
Abstention. Reclusion.
no,
Abstain?
nope,
Recused.
recusal, thank you.
We got
6
it.
members of the board, one's recused, 5 are in favor, none are opposed. Okay. So we're going to be moving forward with that.
Sure.
We'll get it drafted for the next meeting.
Okay.
Yep.
I would just ask that,
Our next meeting is then not later this month, but the beginning of
March.
Okay.
March.
March 2nd.
So
That's President's
March
Day,
2nd,
right?
Since this is February 2nd, yes. All right.
Sorry, the next meeting is March 2nd, right?
Yes,
Okay.
March 2nd. If there's anything that you would like to submit to the board, the deadline is on the agenda, which, again, lost in a sea of documents here. Here we go. February 11th.
Sure.
Okay.
So at the March meeting, you'll have the draft of
There'll be
the
a-
positive deck, and that's
yeah.
just, there's just vote on that, and,
Yes.
okay,
Well, we'll discuss it. We may
Yeah.
vote on it.
sure. Okay.
Okay.
Okay, thank you.
Thank you.
Have a good night.
Have a good night. All right. We do have some other applications. Let's. There we go. All right. Welcome back, Member Palmer. New business.
Happy to be back.
Redless Private Family Cemetery. If a representative could please come to the podium. If you are intending to leave, please do so now. Everyone is obviously welcome to stay. It's a public meeting all the way to the end, but just, if you could please just not leave while someone's presenting, that'd be great. Just give us a moment.
Sure, of course.
Thank you. Cemetery. Okay. Welcome.
Good evening. How are you?
How are you?
My name's Kim Garrison. I am with the firm of Grant & Lyons. We're in Rhinebeck. We're a small land use firm. We specialize in land use, environmental, and residential real estate. We are representing Jason Redless, who's also a member of 209 Cricket Hill Road, LLC. Mr. Redless and his family own a property at 209 Cricket Hill Road, as well as a few vacant properties that surround it. One of those vacant properties is the subject of this application. It is currently a hayfield. It's an open space. It's 8.39 acres in the RU district. And what Mr. Redless is hoping to do is to create a very small private family burial ground on the hayfield property. The cemetery is going to measure 40 feet by 80 feet. It's located in the southwest corner of the property. Really, so this is
And
the
that's
highlighted is 209. That's the highlighted one.
Right.
And then right below that is
Is this
the
parcel.
subject parcel right
Okay.
there. Mr. Redless also owns tax parcel 94821 and 958753, and the one that's right south to the hayfield. So he has a few properties that surround the
These three.
uh,
No.
that one.
This one.
Go down to
So this one.
yep.
This one.
That one, and then the hayfield is the one that's highlighted, and then the property right south of that as well.
This as well.
Yes.
Okay.
And then the just north, the property north of the hayfield is their residence property.
Okay. So these three properties.
Yep.
This property.
Yep. And then
This property.
right there, yes.
Okay. All right.
So it's going to be located, the proposal for the cemetery is a 40 by 80 foot, 3,200 square feet. It actually takes up less than 1% of the property, and it will just be pretty much just a small rectangular area fenced in just to kind of delineate where the burial area would be. On the property, there is also a conservation easement. Takes up about half of the eastern side of the property. It was part of the subdivision back in 2000, I believe. That's marked on the plans, but this will not impact the conservation easement at all. It's outside of the area, and the conservation easement is just allows recreational agricultural use. But again, it's not inside the conservation easement at all.
Okay.
There's also on the map that's been provided by Wesley Chase. He's the surveyor. He is here tonight as well. There's the Iroquois gas pipeline. Again, that's also on the eastern side of the property, and this area will not be impacted.
Okay.
by
Now, is
that.
that separate from the conservation easement, or is that
Yes.
tied to the conservation?
Nope,
easement?
it's separate.
Okay.
And
Because-
I provided both of the Iroquois gas line easement and the conservation easement with my submissions to you.
Okay. Because, yeah, I think you can kind of see where the gas line, goes.
Yeah, I think that looks about right.
And up essentially around their property there, so, okay.
Yeah, I think that looks, yep.
Okay.
But again, this is not, so New York State doesn't really regulate cemeteries. There's no particular state requirements. It's not prohibited under New York State as well. So when it's a family or a private cemetery, it's up to local jurisdictions. In the RU district, which is where this property is located, it requires a special use permit. So we went through the special use permit in our application. It's a minor project, and it doesn't impact anything on the major project. So we think that this should be hopefully fairly straightforward for you.
Thank you. So, and just, it's going to be in this general part of
Yep.
the property?
Yes. Yep.
Okay. I know we, was part of the pre-application meeting, there was concerns about setbacks, and then there was also a concern, I discussed this with the consultants at the pre-agenda meeting about that maybe the headstones are structures, and structures have setbacks, and
Yeah, there's a question about whether or not the headstones need to comply with the setback.
Yes, I saw that in the memo.
Are they structures, are they not structures? Because once they're there, they're kind of permanent, and it could abut someone's future development on the other lot. So we do want to get an opinion from the,
right, because we can't go under the
Unfortunately.
presumption that because right now your client owns this lot and this lot, that this line doesn't exist. It does exist, and someone.
Oh, yeah.
may
No,
want
I
to,
understand.
sell it off in the
I mean,
future. And then,
yeah, I mean, we
build
haven't had a
something.
chance to look into this fully. We don't think it would be considered a structure, just from how typically headstones are considered in other local jurisdictions, but we can certainly take a look at that. I know that the planning board isn't allowed to make an interpretation with what your current jurisdiction is, but
yeah,
like I
mean,
said, we.
it's, our zoning is pretty broad in some sense. Basically, anything affixed to the ground is a structure.
Yeah,
I would just point out that I walked out with Jason and we picked out that site. The thought process was just like
Sir,
a comprehensive plan.
just have to
that
be at the-
everybody wants to see, to
Sir.
preserve
Wesley, would
local-
you like to just come up to the
Sir, you just have to come to the podium. Thank you.
and
And just introduce yourself.
My name is Wesley Chase. How is everyone? I just wanted to say when Jason and I walked the property and kind of looked for a site that he wanted, one of the things that we talked about is we didn't want to put it smack down in the middle of the field with the offsets. We kind of wanted to tuck it into a side yard corner only to preserve open space, preserve agriculture, so he could keep farming those things.
That's
And looking at the comprehensive plan in the town of Dover's goals, I think it aligns with it pretty well. Thank you.
I mean, is there room for just a 25-foot offset so we don't have to get that determination? I mean, is that something they're willing to do?
Where would the 25 of the
From the
side or
property
the
line.
from the which where? Do you have a? I saw you had a pointer, just so I can.
I think 25 feet from the
From the corner.
basically from the corner. So it's 25 feet. Obviously, that's more than 25 feet, but 25 feet in and 25 feet in. was what was being thought of. So that there's not even the question of the setback, since it would just then meet the setback.
Stone, not to the grave.
Correct.
It would be from, I would
Yeah,
assume, from, yeah, because I know that the way that the definition of structure was also a stagnant that was made out of building material, so I wasn't even sure if this really qualified even as building material, because building is defined as a roof structure.
Not in Dover.
Yeah, again,
You can
it's
put a
just-
line of rocks in the road, on the ground, and then you put one rock on top of another rock, you got a wall, so. Let me see if I can bring it up for everybody's.
For the code definition? I think I had it in-
360.
Then a
had
static
it in the
assembly
memo.
of materials.
Yeah.
Would there be a difference if
Yes,
there's
it was,
there are flat
structure
stones?
was a static construction of
opposed to
building
standing?
materials affixed to the
Yeah,
ground.
it's in my memo comment 8.
And then building was structure having a roof supported by columns or walls for shelter. But we wanted to also try to put this, the cemetery in a place that's going to be as non-conspicuous as possible and leave enough room in, there's no plans of developing this property with my client. There's no plans to sell it, certainly in the near future by any means. So we want to try to just, I think, create something that fit nicely into the property, wasn't just in the middle of the field, something that's going to be kind of not interrupt if anybody else should buy this or, use the property for any reason.
Right.
I think building in this sense is not a building. I think it's just an adjective for the type of
Right, a static
materials
construction of building materials.
because a bin and a sign wouldn't necessarily
Yeah, I
have
tried
a
to look
roof.
to see if building material was
Yeah.
defined, and the closest I could find was building,
The
so
wall
that's
doesn't
why
have a
I
roof,
mentioned that.
But
Yeah. So that's why we recommend, that's
Yeah.
why Don Anderson can write a letter formally to the planning board with his opinion on this.
you
We
can
can go
follow.
from there, or you could redesign to meet the 60-foot front yard and a 30-foot side yard.
Right. So that
Vote on
was
it, yeah.
something that's come up.
Of course.
Yeah, or you can go for a variance. What's the easiest path for you?
Yeah.
Right. Was there any other concerns?
I mean, I had a few just things. I'm concerned about the long-term access and maintenance of the cemetery.
Right.
So the Redless family is buried there, friends, family, at some point the property gets sold or transferred, inherited, and someone wants to come visit their family member. Is there an access easement that runs with the land? Is there a maintenance easement so someone can come and maintain the tombstones?
Right. Because the concern is that sometimes cemeteries, just whoever was taking care of them passes away themselves, and no one's taking care of them, so then it falls on
Somebody.
somebody, usually the
Yeah.
municipality, to take care of them. So.
Yeah, we had tried to. I know this was brought up in the pre-conference. So one thing we had, we will probably be doing is a deed restriction, at least to lay out where the property, where the cemetery is located, can't be disturbed. We had tried to think of a way to do access. The problem that we are facing is that there's really not a dominant and a servient piece of property for this. It's all on one piece of property. There's
Right.
nothing, there's no other rights from another property owner to get at this point.
Right.
So, we would be having it, if this property were to ever be sold, I think what we have been considering was just working, usually how it works with false family cemeteries, we've dealt with this ourselves, is that it's usually just based on permission rights, just between the two parties, and that's how we would be handling it. And we've discussed the risks with Mr. Redless. It's very possible that someone might not grant permission, and he's aware of those risks. But we have looked into it to see what other options there were. I know Ms. Polidoro asked if there could be a possibility of a subdivision to kind of corner off this section, but because of the, first of all, there's like a little flag lot, so that would be kind of hard with access. But also, when this property was created in from the subdivision, there's actually is a requirement that there's no further subdivisions to that. So we would be handling it by deed restrictions, which sets out where the property is where the cemetery plot is located, and then through permissions and discussions amongst the landowners in the future.
Okay, so then the next concern, I mean, I guess it's up to the board whether you want to see them provide some maintenance or whether you just want to leave it to, you know, the deal if and when the property is sold or goes to tax auction. The other thing is if you pull up the subdivision, I guess the site plan map, there's some cleanup because it says see driveway easement note 2. I think it's actually note 1, 2, 3, like 5. It should be renumbered, but it's in the application, and then if you scroll, there's a map. Yeah, maybe that one. Yeah, if you scroll down.
Okay.
So it's unclear whether that easement has already been conveyed to the neighbors or whether it's just to be conveyed. I don't know I can't tell the status from the note. And then it looks like there's actually a house in the driveway, so I don't know how there's any access at all.
Did you look into this, Wesley?
house in the
Could you come up here? Just so
Yeah,
I
if you
can,
make that a little smaller, you can see.
Yeah, I'll give you a moment. There we go.
So your question is?
Well, there's a few questions. So
Okay,
does the driveway easement exist now, or is it to be conveyed as part of this project?
So the only easement of record that I found when I originally did the survey and that came up was the planning board of the town of Dover approved this subdivision that is listed on the map of the filed map 11096. Part of the planning board's requirements, I believe, was to have some sort of a road maintenance agreement slash easement. The only thing, nothing was ever filed to satisfy the board, I'd imagine. The note was put on the map. That note I copied specifically from that filed map, put on this. When Jason Regulus did take title, that was added to the end of the meets and bounds description, so it is in his deed. But there is no separate document that's filed with the county.
Okay, I mean, this might be the opportunity to clean that up if they didn't follow through on something they were supposed to do the first time. But then I'm also seeing, is that a house in the driveway?
Nope, that's the driveway going
This
to
is
the
the
house
existing
on
driveway.
Okay, that's an
on
existing
Laurie
driveway.
Kirk.
Yeah.
As you can see, the driveway comes in, and then the parking's here, labeled driveway. The house would be right in here.
Okay,
Go back to, zoom in on right there. Yeah.
okay,
the
so it's just a driveway,
there.
not a house.
No.
Okay, so I just think this is a good opportunity to clean up the access because you want to make sure that there's no question moving forward. It looks like the neighbors are already using it.
yeah, and actually the access is actually owned, it's on Mr. Redliss's property. It's owned by Mr. Redliss.
Right, this is our
Yeah,
property.
I get it. I get it. But if we can clean something up that got overlooked,
Right.
it's a good time to do that.
And, yeah, I mean, we have to remember that, well, you have a survey. I was going to say that the Dutchess County parcel access isn't always
Right.
exact, but you did a actual survey, so. Okay, anything further?
I mean, that was it for me. Do you have
Yeah, we can go through my memo if you want. A lot of it's been talked about already.
Oh, I'm sorry, just before we get to the memo, Attorney Polidoro, just remind the board, does this require a public hearing, or?
It
is
does,
it
because it's a special
optional?
permit.
So it's a requirement.
Yes, you are required to hold.
So there will be a
public
public hearing. Okay, thank you. Planner Werner.
Yep, so that's what number 2 says. First, we talked about what, first comment is just that it's permitted by special use permit. Number 2, it's a minor project, we agree with that, and it does require a public hearing. Acknowledging the easements. We could skip down to number 5, It does require referral to the county planning, because it's along
County road, sure.
a county road, so that referral can be made. We also thought it would be a good idea to get a little more information, if possible, from the health department to see if there's, to ensure that there's no, water supply wells within close proximity to this, if they have anything, any records of that.
Yeah, on the site plan map, there is one well that's shown on the neighbor's property, and I measured it off of the full-scale map, and it was about 300 feet away.
Okay.
And we did check with the Dutchess County Health Department, State Health Department. The separation for cemeteries is 200 feet from wells.
And as part of checking with them, they didn't give you any other records of any other possible wells that weren't on the survey? Okay.
Oh, sorry. We also looked at the aquifer law that was recently adopted.
Correct, yeah.
Because it came up, and
Right.
the aquifer law has added pollutants to the list of, different kinds of pollutants like dry cleaners, but cemeteries is not on that particular list. So
Right.
it just goes to the regular Department of Health regulations.
Yeah. So, yeah, I mean, if there's anything else you can provide to answer 6, you can submit it, but that's what we're asking for. County planning might raise an issue, they might not, but it's going to go to them, so we wait for their comments too. Let's see.
So just doing a quick rough thing here. So if the cemetery was allowed, it would preclude a well on this parcel, kind of in this general corner of the property, then, is what we're saying. Because it would be within 200 feet of the cemetery.
Mm-hmm.
Right, okay. And presumably there can't be a well along the gas line.
Right.
Okay.
Be in the south. Be in the south of that, right by the driveway.
Right. I mean, you'd still have to have
Septic.
septic and a certain distance from the well, and okay. Okay. Just, I don't know if that needs to come into the consideration here, that we're are we creating a situation where this parcel forever in the future wants to build a house here, then gets limited as to what they can.
That's no different than
Do.
if that was a septic system or a well itself, and we do this all the time on other lots where we
Yeah.
get septic
Yeah.
within 10 feet.
Sure. Yeah.
So
Okay.
the fact that it's a cemetery is not it has a 200-foot separation, no different than a septic system would.
Right. So like,
Or a fuel tank.
what you're
so-
saying is, if someone were to build forget a cemetery, someone were going to build a house here, and they wanted to put the septic there,
Yeah.
it would preclude then a well
Same
being,
thing.
okay.
Correct.
Yeah,
It would
that's
be
true.
identical because
Right.
they're allowed to be within 10 feet.
Yeah, I guess my only thought was that it's adding another precluding
Another
thing.
burden,
Rather
yeah.
than just a well and a septic, it's a well, a septic, and now a cemetery.
But it's not absolute too with the health department. So a septic system which would actually produce pollutants to go in the ground,
Right.
you could get a waiver for putting a well or a house within that 200 foot if they couldn't get anywhere else on the site.
Would there be a preclusion from putting the septic next to the cemetery?
No.
Okay. All right. Never mind.
But there are other waivers.
I just didn't want to, we basically just iced out this,
Yeah.
No,
parcel that you can't do anything with it.
No, there's other remedies for
There's
it.
also the added consideration of everything else going on, so.
Right. Because the easement looks like it goes right.
Kind of
through
cuts right
that.
down the middle of it there. Sorry, please continue. Okay.
Let's see. Number 7 just acknowledges that the applicant did provide a pretty robust analysis of the special permit findings that are in your code. I don't have any objections to those. I think those are just something to take a look at when it comes time to a decision. The planning board has to make those findings, so I think the applicant provided some good background there as to why it meets, it warrants a special permit. Let's see. Talked about the structure issue. That's number 8. Recommending the code enforcement officer weigh in on that.
That's right, okay.
Thought it would be a good idea to add a bulk table to the plan to show what those standards are, if they can be, especially if it's going to be considered structures, have that in there.
Is it proposed that the cemetery would have a fence to delineate it as this is the cemetery and
Yes.
that's not the cemetery?
Mm-hmm.
Okay.
And I think some changes have been updated to the site plan that we'll submit
Okay.
once
I
it's
just,
been.
well, just also because there's typically, we'd have to look at this particular zone, but what you have proposed is the cemetery right up against the property line, so then if you put a fence, can you put a fence up against the property line in this zone? I just don't know off the top of my head, so.
Well, if the fence becomes a property line itself, it's allowed, because that would be a property line delineation.
Sure,
You couldn't
okay.
stop that, that state law allows it.
Right.
I believe I took a quick look at this. I believe there was a height limit to it, but I'll double check that. I don't
There is.
recall.
Yeah,
if it
there
was
is.
4 feet or something like that.
6, I think.
It's 6 up
Six.
there.
6, okay.
But you couldn't put the fence 2 feet off the property.
Well, you can put it on the property.
On the
That's
property
interesting,
line,
yeah.
because then it's a
Right.
property delineation.
Okay, good to know.
The quirks.
Good way to think. All right.
Yeah, so again, if those are determined to be structures, you know, you could either seek an area variance or propose modifying the setbacks to make it comply. Number 10, just noting that this is in the aquifer overlay. We usually like to see a note on all plans that acknowledges that's the case. So
Right.
just adding that. Seeker, you can't really fit it into a type 2 on a cemetery. I think it's more or less an unlisted action, which is the short form is acceptable. They provided the version that's the outdated version that's on the town's applications, which is in the process of being changed. So just recommend completing the new, you know, the latest version using the mapper. So it
Yeah, we'll
gets a
certainly do
complete-
that. I used the one that was provided with the
Sure, that
application, but I
happens.
used the EAF mapper as a source, so it
Yeah,
shouldn't be
it's
too
fine.
bad.
If you just generate one with the mapper using the latest format, and we'll take a look at that. It does. We did take a look at what the mapper shows. It does flag it for potential endangered species, but this is a very small area. It's a cemetery. It's, you know, mostly going to look natural. I don't think we have any issues with endangered species habitat disruption in this area. So not concerned about that. And again, the last comment, if this is going to be moving forward with a ZBA involved, the planning board would be required to coordinate that environmental review with the ZBA. But again, we don't know that yet, so we'll figure that out. So our recommendations were to discuss these comments, maybe get the CEO interpretation going on the issue of the structure, since the code is pretty vague there. Classify as unlisted, and we can make the referral to the county. I think there's enough information to do that, just to get the clock rolling on that.
Right.
And you have an option to visit the site if you so choose to. But I don't think it's
I
ready
think
to
a site
set it.
visit would be helpful.
Yeah.
There's, I mean, because just a field, the only, it looked like on the survey that you put iron pins in the ground, like the only way we'd know this is where the cemetery is proposed is because there's markers in the ground, right?
There's markers out there, is that what?
That's what I'm asking. Yeah, if you want to come to the podium.
The markers are already set. The
Yeah.
day that we went out there, I set them in the field,
Okay.
and they're big iron pins.
They're
on
obvious.
Right now. Yeah.
They're obvious, okay, all right.
Oh, it might be
And I
covered.
believe that
Under
there's 36-inch lath
Well,
next to
that's
those.
true, it's covered in a foot and a half of snow right now.
Yeah, it's going to get out there.
Sidewalk might have to wait.
Yeah, it's pretty snowy. Yeah.
Um,
Or you might have enough information that you don't need.
Little bit of nesting going.
How high were the pins that you put in?
The pins are flush with the ground, but there's
Oh.
36-inch lath next to those.
What is laugh?
I would point out that pins are also called monuments,
Stakes.
but
Oh.
some monuments are not
Stacy,
building material.
Yes, yes,
Called that.
Yeah.
Okay.
You just mark a point
gotcha.
rather than a grade.
All right, so,
Let's wait till it gets a little colder.
colder, you want to wait till it's
Then you can
actually
walk
colder?
right on the property. There'll be ice.
That's when we should go out.
I agree, Joe.
All right, so maybe we won't have a sidewalk, we'll see. All right, well, we can at least refer the application to the county under 239M and classify
Yeah,
the project
and I
as an
think-
illicit action in secra.
Yeah, and I don't think we're ready to set the public hearing until maybe if they're going to make a resubmission with possibly some changes.
Right.
Then we could talk about doing that next meeting.
Yeah, I think the changes that were provided on the updated ones weren't too involved. I mean, we would like to, if we could set a public hearing, that would be wonderful, and if we need to hold it open, we can certainly hold it open, but, I mean, I think,
Up to you.
Yeah, I
We're
mean,
going to be waiting for the county.
right, and I mean, I believe the county's been rather responsive. I mean, the next meeting is 4 weeks from tonight, so we might get back to us within these 28 days. All right, so this can all be one.
We're just gonna do by motion, yes.
Yeah, these can all be one big motion. Okay. Oh yeah, please.
One comment's relevant to the wells. I know all the wells that are out there were probably already located by the surveyor. So a general note that the health department would like to see anyway, but we should, if just in case they don't, is a generalized note that says all known wells within 200 feet of the cemetery are shown on the map.
Okay.
That should cover that, even if it's known. I mean, obviously, as a surveyor, he can't guarantee there's no hidden well somewhere.
Sure.
This is just based on his requirement of a surveyor to locate them anyway.
Right.
So it's just a generalized note for the public. Second question I have is, since this is just going to be a site plan and a special use permit, there's really not going to be a record of this cemetery filed. So if I was a surveyor 30 years from now, and those laths are gone,
Yeah.
and the rebar have been filled in with whatever dirt, how would I even know to go look for that cemetery if it wasn't some type of record
Right.
of
Well, we
where
were-
that cemetery was going to be?
When if there's ever with the deed, a deed restriction on there, we would be having as a Schedule B.
So you're going to
site
file a
plan map.
correction deed.
I wasn't thinking a correction deed. Just
So
when
until
this is
someone buys it, the deed
But,
won't get filed.
I mean, it could go into foreclosure, in which case we get a deed with no information.
That's what I meant,
And the
unless
next
it's-
chain in title.
Unless a new deed is filed, having a draft deed to maybe get filed down the road may never happen. And I've done numerous surveys where I've run across a cemetery out in the middle of the woods just by tripping over a headstone.
Oh, okay. I didn't know where you were going with
And then you start looking around and saying, well, how big is this thing?
that. Right.
So what's the recommendation? Is it a deed? Or like a declaration that goes, or is it some kind of file?
Well, it could be filed at the town here. I mean, I do, as Wesley probably does, due diligence. We check with the towns as well.
I say most title searches don't.
I know they don't,
Yeah,
but
they
a good surveyor does, and
Yeah.
quite honestly, new standards that are coming out are going to require or recommend that, but a good competent surveyor in your state will check with records at the town. So we could file something here at the town.
Right. What's the concern with just having it filed with the county? That
Well, you could,
all deeds.
it would require a correction deed, though. That's the only way to do it.
Yeah, I'm not
you
sure if
file
it would
a
really be
map?
a correction deed because it's not changing anything. It's
Well, you're
adding
adding
something
to it. You're adding to it.
Yeah.
So I would leave that to the lawyers, said what you call it.
What
Okay.
about filing a map?
I was thinking.
You can't file a map because we don't file maps in Dutchess County unless it's a subdivision.
Subdivision.
You can't file a miscellaneous, no one will find it.
Yeah, but no one looks at the miscellaneous filings. Filing in miscellaneous filings, Dutchess County is worse than even not filing.
Okay.
Okay.
We don't go look at the miscellaneous filings, it's not recorded anywhere, and you would spend 3 weeks looking through it. Unless you tripped over it, you wouldn't know to do that.
So why don't we just put it to them to come up with an idea, and we'll keep thinking about it as well.
I was just, throw it out there that, it's nice to have it on this map, it's got burying distances, it's tied, we know we got rebar in the ground, but what happens in 30 years?
Well, I thought I had, and then, remember Sador just said it, was you're going to build a fence. Can that be part of the, we approve this within 1 year, you build a fence? So this is the cemetery, there's no one buried there yet, but this is it?
But the fence could be down in
Yeah,
30
fence could
years.
fall down,
Sure.
disrepair.
I'm thinking 30 years, not 3 years. That's
Sure.
usually where you have a problem is the cemetery gets used, it gets filled, and then 20, 30, 40 years later, it disappears.
I mean, I was just wondering, even if just, as Mr. Berger said, you have this as a file in the town,
Sure.
and there's approvals associated with it, and would just be part of the file, and then when
Right.
it gets sold, we would have it as Schedule B with the map and the deed restrictions that lay it out.
I think a
Right.
declaration probably now as part of this, and then when you sell it, of course, you can add more, but something that's going to be of record now, so we don't have to wait for some future event where, people will forget what they were supposed to do.
Okay.
Just something simple. I don't want to make it complicated. I just want to get a record
Okay.
straight on it.
Thank you.
Everything else, I have no more comments on that.
All right. anything further? Any member of the planning board have anything further on this?
A question.
Yes.
Is there going to be anything in the deed restrictions, or is there going to be anything that's going to protect the graves, from any maybe future owners?
We would have it that it wouldn't be disturbed. It would be marked on the map which would be provided in the Schedule B of the deed, and then we haven't drafted the language yet, but it would have it so that it can't be disturbed.
So a new owner couldn't just,
Go in
dig
and-
up the graves?
Correct.
Oh, my God.
The people will be, well,
Locate.
that's happened before.
how they
that
built
they bulldozed right over the graves. That's exactly
I've
what
moved
happened
many a
up on the
grave.
ridge.
Graves can't be moved. I
That was
moved.
Well, that was our
many.
intention, to have some sort of protection,
Having there
can't be
tomorrow,
disturbed.
Mary's
This
and
guy up
Wappingers
on the ridge
moved it up
did see
400
like them
for a storm sewer.
people
Wow.
who didn't even know what they were doing on the lot next to him. The machine was out, starting to work on the lot, and they didn't even realize that there was a cemetery there, but the neighbor did. I mean, the headstones were all gone, so there was no evidence there that it existed.
So, a map being filed, and
Well, map being filed I'm not sure that's practical because there's no subdivision. You can't file a miscellaneous map.
I thought you said a map with the town.
Oh, with the town, yes,
Yeah,
filed
right.
with the town somehow.
Okay.
Yes.
Yeah, because I was also wondering just how a declaration would work for filing. Like, we can certainly be thinking about that, but it kind of goes with the access question we had, is that there's no real parties to it except for Mr. Redless at this point. So I don't know how
And
we can
family.
be filing a declaration, but
Okay. All right. I don't know if there's anything else for us to discuss at this time. I'll need a motion to classify this project as an unlisted action under SECRA, to refer the application to the county under 239M, and to set a public hearing for Monday, March 2nd at 7 p.m. or soon thereafter, as the planning board can hear such public hearing. Motion made by
So move.
Member Villano, seconded by Member Palmer. Discussion. Seeing no discussion, all those in favor say aye.
Aye.
Aye. Any opposed say no. That motion passes 6-0.
thank you very much.
Thank you. You'll just need to see.
I have a question about escrow. Does it have to be increased?
Most likely. If
Okay.
we're going to more
Maybe
than a
increase
couple of meetings.
right
yeah.
now.
Probably.
Would you like me to, I can contact Ms. Van Millen?
Well, we would need to vote on
A motion?
increasing
Okay.
the escrow. You'll be seeing Secretary Van Millen for the
Public
can
hearing.
just
public
see-
hearing placard. Yeah. So what do we think?
Initial was 1,500, is that right?
Trying to see where it is. Right now, there's $1,100 in the escrow account.
Okay. I mean, just when it gets to 750, it needs to be replenished, right? That's what the.
Yes.
Does it really need to be increased? I guess is the question. Just when it falls below half, it's supposed to be
Understood.
The bulk of
replenished.
honestly, I think the bulk of our review has been handled at this point. I
Right.
don't think it's been depleted from that, so,
Okay.
but, yeah.
Yeah. So your client may need to replenish the escrow before the
March
meeting
2nd?
4 weeks from now,
Okay,
based on the
understood.
bills that the town receives from our consultants.
Sure, if you just send me an email and we'll
All right.
forward that along.
Thank you.
Thank
As
you.
far as the interpretation from the building department, are we just putting it on the applicant to do?
Well, I mean, yeah, it's just
You want to do a formal referral to the zoning administrator, zoning enforcement officer?
Probably better.
The town board, we increased the initial escrow to $2,000. That's why I was waiting for the new applications to be done.
Okay, got it.
All righty, so it is going to be increased.
Okay.
so. You have or have not had any conversation with the code enforcement officer?
I had a conversation, well, I spoke with Mr. Johnston last year when I was starting on this application because I wanted to know, because it didn't specify it was public or private cemeteries. I wanted to get
Sure.
his interpretation on that.
Right.
So I did speak with him briefly on how to get the process started, that it was going to require a special use permit. We did not talk about the headstones, so.
Okay.
Can I give him a call?
Yeah, I mean, you can just,
You should talk to Don Anderson.
Yeah.
Don Anderson?
yeah, Don Anderson's the building inspector and code enforcement officer. Mr. Johnson is,
I think for the record,
Typically
we should
code.
just, you know.
I'll
make
need a motion to refer this application to the building department for a code interpretation. Motion made by Member Palmer, seconded by Member Williams. Discussion. Seeing no discussion, all those in favor say aye.
Aye.
Aye. Any opposed say no. That passes.
Then you can reach out to him
Passes 6-0.
directly.
Okay, and
give him the
understand, have a
information
little
and-
discussion with him. Sure.
Yeah.
Okay. If I do have a quick question regarding your comment, Ms. Paladero, about the access easement. Because again, this is a kind of a question. I don't know how we would be doing an access easement when there's really, it's certainly some of the properties is owned by Mr. Redless to Mr. Redless. You know, I guess it's, you know, the access is, it's a part of this application in the sense that we need, you know, it's established that he has access to his property. I guess I just didn't realize how it would be affecting the access to the cemeteries.
So the note on the map was just a little vague as to whether this was something that existed or something that had been granted previously.
Could we just clarify
So
that note,
maybe
perhaps?
if you clarify that access was granted to neighboring parcels via note on filed map such and such, so that it's, I mean, I would like to have something in writing cleaned up, and the neighbors, you know, they might come to the public hearing and say, hey, you know, we need an easement, but, you know, it's not required for the cemetery. It's just a good time for you to clean it up.
I understand. It's a
Well, I
question
think-
of getting other
Yeah, and I think
neighbors
there's also the
involved
concern
and-
that, you know,
yeah.
we want to prevent maybe 40 to 50 years from now that Mr. Redless's grandchildren want to go visit his grave, and the people who now own that parcel are like, get off my land.
Right, and also if the planning board's approval wasn't followed through with the last time, you know, there could be a violation, or we'll have to pull the old approval to see what they were actually requiring.
From the subdivision?
Yeah,
Okay, I can see if I can find that information.
yeah, that'd be helpful.
Good catch. Thank you.
I'm sorry?
No,
Oh.
something with the computer.
Oh,
Okay.
I can't help you there, sorry.
Thank you.
All right, thank you very
Thank you
much,
very
I appreciate it.
You have
Yeah,
a good evening.
Kim, I'm just getting to the age where I've seen things not followed through now, and it's like, just trying to prevent that.
Okay, next on the agenda, Garofalo accessory apartment. Please come to the podium.
So they have to file with the interstate cemeteries reports, so you should go look into them, put them out there. This is a filing that they have to do.
Good evening.
Hi, how are you?
Good, how are you?
Good.
All right, so you are before us because you are looking to have an accessory apartment on your property, which is sideways, and give me a moment. There we go. Okay, so yeah, if you could just run us through what you're looking to do.
Yeah, we're just looking to add on to an existing garage space that we have.
Okay.
It's,
Which is this here.
which is out there,
You're
yeah.
looking
when
to
the-
add on this dark structure.
Yeah, he put the
there.
proposed to add it on. So the existing structure is 480 square feet, and then we were going to add on another 320 to make the total about 800 square feet. I think we
Sorry,
need-
so if you could just say like, the current.
So our current garage
Yes.
is 480 square feet,
Okay, so that
as currently built, yes.
that shape is 480
Yes,
square feet.
that's the garage,
Okay,
yes.
because this shape appears to be bigger than that.
I think
shape.
the way he did it was
Okay.
he was just trying to propose like how it was going to be, I guess.
Uh-huh.
I'm not sure, but he did like the 40 by 20 because that was like the existing, like the whole structure will be 40 by 20.
Okay, so the whole structure will be 40 by 20?
Yes.
And it's
One-
presently smaller than that?
It's 480 square feet.
Okay.
The existing garage, yes.
24 by 20?
Yes.
Okay. All right. So you're adding on 16 feet and,
No single story, like no two-story, just one level.
one level, okay. All right. And it'll cease to be a garage, it'll be
It will no longer be a garage.
an apartment? A single-story apartment?
Yes.
Okay. All right. And okay, anything further?
No.
Okay.
Sorry.
All right, let's,
Never done this before.
you're doing great. Planner Werner, let's,
So the
your memo.
total size of the apartment will be the 480 plus the 320.
Right, so you're adding on 320, okay.
Yes.
Okay. Yeah, we can go through the comments. A lot of them just been addressed. So it was a question. Let's see. So it's a special permit. It's a minor project. It does require a public hearing. Technically, the planning board serving as the architectural review board has to approve the architecture for the apartment. That's part of your code. So, do you have a floor plan, even if it's like very rudimentary, preliminary, just that you can submit?
Well, it's just kind of like a mock-up of what we're planning to do.
That's fine.
We have our, Jeff Ward is our
Your GC?
construction guy, yeah. I don't know, who do I show? Do I just show this to somebody?
I think I'll have to submit
But
it
this-
to Marilyn
Yeah,
after you're done speaking.
Yeah, when you're done speaking.
Okay.
It doesn't-
For the
Yeah,
next,
we do.
yeah, by the next submission deadline for the March meeting, if we have that, that would be great.
Okay.
And I think that also includes, it's not new construction technically, but are you changing the appearance on the outside substantially? Like,
No, I
this
mean,
is-
right now, we live in a log home, so it has
Yeah.
like log siding, so we're
Okay.
taking the log siding and we're just doing like a regular like board and batten.
Okay.
The color is just gonna be like a beige brown to match the surroundings.
Maybe some photographs of the existing and just an explanation of how it's going to change would help.
Okay.
Because they have to, this board has to technically give it architectural approval as well.
Okay.
So,
It's really not changing, I mean,
Okay.
the structure itself, it's just other than just putting new siding on it.
sounds good.
That's
Okay.
it.
Let's see. So it doesn't require any referrals to the county. It's far enough away from any of those determinants. Doesn't need the ag data statement. Have you been in contact with the health department about the existing septic system, and would it support an additional?
I did, I went
Dwelling,
and put
okay.
in like a FOIL request for documents for whatever
Okay.
they had, and they did give me documents that have the current septic that's filed with them, and that
Okay.
it states on one of the pages that it's good for up to a 4-bedroom home.
Okay. And right now, your existing house is
3.
3? Okay. You want to add to that? Or when I'll get to you, or you want to? Okay. Sure.
So the board's going to need even though you have a size for a 4-bedroom and it's 3, you're still going to need to get a determination from the health department that the additional apartment fits into that. So it's called a use letter. So
Okay.
it's just, this board doesn't make that determination, but it's going to rely on the health department
Okay.
stating that your proposal does in the system you have, because you have to connect to it.
Okay, yep.
So they're going to want to see a drawing that shows how are you connecting to it. Did the septic tank that they put in for the 3-bedroom that you have, was it put in for 3-bedroom or was it put in for 4-bedroom? So is your
Okay.
septic tank big enough? Is your D box big enough for the additional?
Bless you.
Did they put in? Sometimes when these systems were approved for 4, they only installed for 3.
Okay,
So you need to look at the FOIL, but you're also going to have an engineer work with them and just touch base with the health department engineer exactly what he needs or they need.
would it be like a septic engineer, like someone who puts
Well,
septics
civil
in?
engineer, yeah.
Okay.
Yeah. But you want to talk to the health department engineer first to find out what exactly they're going to want
Okay.
to give you that letter for this board to show that the connecting of this addition to the existing system and the well.
Mm-hmm.
uh,
So Engineer Berger, so I'm seeing the well there,
Mm-hmm.
but I'm not seeing the septic.
The septic is actually under the chicken coop. It's
Under
in,
the-
the leach fields and all that are run underneath.
So that's something they're going to be concerned with because they really can't be under a chicken coop. So that may be something they're going to be concerned with.
Well, the boxes aren't under the chicken coop, they're past the chicken coop, just the pipes.
It's just the, like
So
the leach field.
The leach fields, yeah.
The septic, my point was the septic needs to be shown on.
You need to have, well, the health department will require that, yes, and we will
Have them
too.
at it, okay.
Basically, when you go to the health department and talk, they're going to ask for a plan that shows where the septic system is, how it is. If those lines are under the septic coop, are they H20 loaded? These are things I didn't want to point out here because that's something you're going to deal with the health
Okay.
department. But there's an entire procedure that they do when connecting a new building to an existing, one verifying that the system is there, that it was installed for 4 instead of 3, that it's in good operating condition, which may require, depending on the age and condition of the system, records of the septic tank being pumped, televising of the lines to make sure that they're still functional. They're also going to want to, how are you going to feed the water? Are you going to come off the existing building? So if you're coming off the existing building, if your current well is treated with chlorine or UV, those are things the health department's going to want to know
Okay.
because they all fit into the standards. And, you know, I don't want to go through here to take up the
Sure.
planning board's time, but there's a certain amount of engineering that needs to be described and done to verify that the existing system for the existing house can support the new addition and how the new addition is going to connect to both the water and the sewer, and verifying the distance from that well to the septic is 100 feet or 200 feet, depending on the grade.
Okay.
Yeah, so that's number 6 ties into what we just kind of talked about too. I think maybe it would be better just to have the survey stand on its own and not show the addition like that, and then maybe having a separate exhibit that just kind of shows the
Just have him take
the
it off.
footprint. Yeah,
Okay.
because it's technically supposed to be a survey, so you can't really show proposed on a survey. And then include the septic system location there as well,
Okay.
and the connections for water and sewer. So number 7 just talks about the definition of an accessory apartment. Dwelling unit occupying the lesser of 1,000 square feet or 30% of the floor space of an owner-occupied structure containing a principal use at a single family or non-residential, or a dwelling unit no larger than 1,000 square feet located in an accessory structure on an owner-occupied property. So this fits into the latter part of that definition. It sounds like you're 800 square feet if you include the existing plus proposed, so you're not going over 1,000, and you're above the minimum, so you shouldn't need any variances related to that, so that's good.
But
You
following
answered-
that comment,
Yeah,
should the map be corrected so that it matches?
yeah, I think the, like I said, a separate exhibit showing the addition and the proper square footage for the
Okay.
footprint, just accurately shown.
So should they have it where when the septic,
No, I think the survey should
Add it
include,
on, they
the
could
survey should
correct that
include the
too.
septic and all that stuff, right?
I agree, the survey should show what's existing.
right, including
And
the
there should be a second sheet that shows what's proposed, which will be the addition, the line from the line either from the well or from the house that feeds the new building, the line from the new building to the septic tank, any improvement to the lines that are needed for this building, all have to be shown. Dimensions, separation, those are all health department requirements, should be put on that separate map. And only what's existing should be on the survey map.
So existing for survey, and then you could have like a separate sheet that you can call like special permit site plan or something like that, that just
Okay.
kind of details all this stuff for the apartment that you're adding. So the second part of comment 7 was just, we didn't really know the square footage. I think a lot of that's been answered. If you do have, a conceptual floor plan and the height information, just submit that as a response to this.
Okay.
And you're not going to be, obviously this will be rented out.
No,
not
it's for
gonna-
my mother.
Oh, okay, so a family member will be residing there. Okay. And then on that second sheet that you're going to call the quote-unquote like site plan, it would be good to have just a zoning compliance table that shows that this is all going to be complying with the RU requirements, the
Okay.
setbacks and everything else.
So it would pretty much be what's the setbacks are now currently on this new, like additional
Yes.
site plan?
Just, yeah, what we like to see is a table of the bulk and area requirements for the RU district and how this is meeting it, like what's required and what's proposed to show that you don't need any variances with the ZBA.
Okay,
So what you may change on that table will be existing and proposed. The setback to the new building isn't there now. And that
so
may be
essentially
different.
we're taking off the proposed part of it and having him add on like where this
That's on the
current.
site plan versus the survey.
Yes,
Site plan will have a bulk table with all the setback, bulk regulations that show what's there now
okay,
versus what's going to be there afterwards.
okay,
So the after will include the setbacks to the new building addition. And there may be impervious coverage difference because of the coverage within the zone. You're adding not a lot, but that shows a change.
okay,
And so any changes that occur within that bulk table have an existing and proposed. Any engineer you hire will understand that. Just tell them they need a bulk table.
okay.
Let's see, moving along. Then a couple of notes to be added just about the aquifer overlay and the stream corridor. Just important to have those added to the plans. Again, an engineer will understand these comments if you work with one.
Okay,
Not concerned about the stream corridor overlay, which is way to the east of the property, it seems.
it's on the bottom of like a hill.
Yeah, and you're well beyond the setbacks of that, so that's not an issue. So, yeah, that's the bulk of the comments. For seeker, technically, you're creating a two-family arrangement, technically two different units, even though you're going to have a family member there. It's a type 2 action under seeker. It's up to 3 units on an approved lot, and you have 2. So you can lump that into a type 2, so you don't need to do any environmental review. The board can type to it. You don't need to submit the EAF or anything else.
Okay.
So the recommendations would be for that classification to be done by the board tonight. We could discuss readiness for a public hearing, assuming a lot of this stuff gets addressed by the deadline for the next meeting. You could do a site walk if so desire, but.
What's
a
the
lot of snow on it.
likelihood that? So no, I didn't even. What's the likelihood that you would have the documents as discussed by our consultants in the next 9 days?
Oh, not gonna
Okay,
happen.
all right.
Yeah, no, not
So
9
I
days.
think we'll hold off on setting a public hearing
Yeah.
for now.
Yeah.
Maybe like 4 weeks, but yeah, no, not,
Okay.
not 9 days.
Yeah, so maybe it's that, if you, submit it as soon as
Yeah, as soon as we
can,
get it,
and,
we'll put it in.
obviously what I would suggest is that you kind of maybe rewatch this to get down everything that
Okay.
they're suggesting
Yep.
for you. Yeah, I think we'll just hold off on a public hearing for now. 'Cause it really wouldn't be enough information. You don't really have a full
Sure.
application. I mean, we obviously can see what you want to do,
Mm-hmm.
but in terms of the requirements,
Completeness, yeah.
there's no completeness.
So just basically submit everything that they've suggested and want us to
Yeah.
submit for the next
Right.
meeting.
Yeah,
then-
and if you
okay.
could do that,
April 6th.
see, what's the next? So the next deadline would be March 18th for the April 6th meeting. So
Okay.
that'd be, like 6
Yeah,
or so
that's
weeks from
doable.
now.
Okay.
Yeah.
Yeah, March
Yeah, there's
18th
another
is the
What?
I
documents have to
didn't-
be in by the 18th, so just put the 18th, yeah.
There's a March 16th meeting with a deadline of February 25th.
Okay. Do you think you could,
We can try.
3 weeks?
If we can, we will. If not, well,
I think we just
it'll
still
be the
need
next
to-
one.
Yeah, I mean, I would think maybe, I don't know if it makes sense to set the public hearing. If it may or may not happen, then.
Well, we still got like 22 inches of snow.
Yeah, no.
Yeah, right. That's just, yeah.
No, it's fine. We'll just,
Yeah.
if we can get it in, great, and then
Sure,
if we set it
okay.
later, fine.
All right.
Yeah.
So let's
We have
hold off on that for now.
a resolution to type it as type 2 tonight, or we can hold off.
Right, we could do that.
Yeah.
Well, if you did the resolution tonight for them, that would help them expedite going through the health department, which
Oh,
won't
with
do
Seeker,
anything
yeah.
without that.
Okay.
Sure.
That's true.
So
Okay.
that does help them move forward with the health department.
Okay, thank you.
Sounds fair.
All right. Before I read this,
I did leave
see, there's a
open
blank
how many
spot. So it's
square
it's 800 square feet. Right?
Yeah.
Into a 800 square foot single family. Okay. Any further discussion before we get to this? Anybody have anything else to add or question?
Nope.
Okay. Like you said about the snow, I mean, I think we'd hold off on any kind of site walk at this point too, so, okay.
Gotta be below zero.
Resolution to classify the action. I'm sorry, is it
Garofalo.
Accessory apartment. Whereas the applicants have submitted an application for a minor special use permit with site plan approval to allow the construction of a 16-foot by 20-foot addition to an existing garage.
That's right.
The conversion of that space into a 800 square foot single bedroom accessory apartment, known as the project, on property located in Dover Plains, identified as tax parcel number 7063-00-014690 in the RU zoning district, known as the property. And whereas the project is shown on a plan entitled Survey Map Prepared for Garofalo, prepared by Blind Houston, Inc., dated January 8, 2026, sheet 1 of 1, the site plan set. And whereas pursuant to section 145-12C of the Town of Dover zoning law, one accessory apartment per single-family dwelling may be located in an accessory apartment or principal structure, and the accessory apartment shall not be counted as a residential unit for purposes of determining density. And whereas pursuant to section 145-74, an accessory apartment is identified as, quote, a dwelling unit occupying the lesser of 1,000 square feet or 30% of the floor space of an owner-occupied structure containing a principal use that is single-family residential or non-residential, or dwelling unit no larger than 1,000 square feet located in an accessory structure on an owner-occupied property, end quote. And whereas an accessory apartment is a permitted use in the RU district subject to special use permit approval, and whereas pursuant to section 145-12C of the Town of Dover zoning law, no special permit shall be granted for an accessory apartment without approval or certification from the Dutchess County Department of Health on the adequacy of the septic system. And whereas the applicant has submitted a short environmental assessment form, or EAF, dated January 13, 2026, pursuant to the State Environmental Quality Review Act, or SECRA, and whereas the property is not within 500 feet of a state or county highway, now therefore be it resolved that the planning board hereby classifies the project as a type 2 SECRA action. This resolution is being offered by,
So moved. Whatever it was, both of us.
I don't know who's first. Member Sador, seconded by
Member Williams.
Member Williams. Thank you. All right. Discussion. Okay, seeing no discussion, a resolution to classify the action. Secretary, please call the roll.
Member Williams.
Aye.
Member Milano.
Aye.
Member Sador.
Aye.
Member Palmer.
Aye.
Member LaRobidier.
Aye.
Chairman Courtine.
Aye. This resolution passes 6-0. Anything further? Okay. Just you want to print it out tonight and I'll sign it tonight and that way they have it, or
Say that again?
you want to print this out tonight and I can just
Yes,
sign it
I'll
tonight?
try.
That way they just have it.
Yeah.
Okay. All right. So if you just want to stick around for a little while, you can.
Okay.
Just have one more application.
Either that or I could just email it up to them after you sign it.
That's true. Yeah.
I'll
Have a good
email
night.
it up to you.
Or you could wait for it. Or you could wait for it.
Thank you.
But like I said, my suggestion would be definitely rewatch this very boring thing that just happened, and they have some really good advice for you there.
Oh, for sure.
To
I think it's all kind of written down to
Yeah, no.
Yeah.
yeah,
So your surveyor knows who to work for, but you also got your FOIL from the health department. You may want to consider talking to that engineer. Because he already has the data.
Yeah,
If the
Brian
other
knows.
Engineer's not around, he works with several engineers, your surveyor, so they'll know. Now, if either that works out, the health department, talk to them. They'll give you a list of all the engineers that work in this area.
Okay.
That's step 3.
Okay, perfect. Thank you very much.
have a good evening. Thank you. Good evening. Thank you.
When they consult with them, the better we are.
Yeah,
Yes.
Brian's good. He's,
Brian knows who to-
I'll scan it in and put it with the rest of the work.
yeah.
Thank you, my dear.
Thank you. Have a good night.
Okay.
You too.
Next we have, is it Petrie?
Petrie.
Petrie? Petrie, okay. Petrie lot line change. Let me bring this up. Okay, so, right. This is for a lot line change along Westover Road. Okay, so if you could just tell us a little bit about your project, and then we'll...
Sure. My name is Brendan Johnson. I'm with Johnson Surveying, representing the Petrie application. So essentially, it's 917 and 921 Westover Road. They're each 8.1 acres, and they're trying to make 917 a little bigger by 3.66 acres. They own both lots currently, and they're looking to put 921 on the market, and he wants just a little extra land for his own.
Okay. All right. Let me go back to this.
Perfect.
Yeah.
Okay. Wrong part of town, but good.
Hmm?
Wrong part of town, good. I was looking to see.
Let's see.
There you go.
All right. Okay, so this parcel and this parcel.
Correct.
Okay. And again, the proposal is to take from which parcel and add to which parcel?
Take from the top parcel and give to the bottom parcel.
The bottom parcel, okay.
Essentially,
So the top parcel will become smaller, the bottom parcel will become
Correct,
larger.
yeah.
Okay.
And the top parcel is going to be sold?
Yeah,
You said?
that's the
Okay.
exception.
Okay. Okay. There's so many documents open, I won't even show like the little...
Close them. You can close them.
Close them.
you know.
I'm so scared to
More
close
screen
any of
than
them
mine
right
does.
now. I don't know which one's which.
Yeah.
Close them all, clean it up.
We don't
I'm just glad I was able to forego the computer rebooting itself twice already.
And I checked it this morning.
You see, I'm trying to close these, right? All right. Okay, so that document. And where? Let's go to your memo.
Sure. Yep, so it's a minor project. It will require a public hearing, as lot line adjustments do in the town of Dover. No new development. We just got the reason for the lot line change, which we asked for. So the question about number 4 talks about normally a lot line change wouldn't require referral to the county, but if it involves a variance, it would. And we can talk about that, it's further down, but whether or not this might require a variance on the northern parcel becoming a flag lot, whether or not it meets minimum width, I think that's the issue, so we'll get to that. So we'll move on to number 6. There's 2 zoning districts, so it would be helpful if you had the zoning table show both
Yeah.
requirements for both districts.
And also, what does that mean for the minimum acreage for?
So the RC is on the back. There's a stream.
It's on the
that
back.
comes
Yeah.
across the back, and
Yeah.
that must be the delineating line. It's hard to
Yeah.
tell because
Probably.
the aquifer overlay is
Yeah.
on top of it.
Yeah,
But it's so far in the back that
Right.
it doesn't.
yeah,
I don't
nothing
think
that's,
it'll affect anything.
yeah, it shouldn't affect anything, but
Okay.
just acknowledging that there's two districts here is all that's really saying. The aquifer overlay note is usually added to these, so we'll be asking for that with number 7. Same with 8 about the stream corridor, which is also at the back end of the site, as the applicant said. So number 9 talks about the rear lot slash AKA flag lot condition. So the northern parcel is going to be becoming a flag lot or a rear lot. That's 921 Westover Road. The frontage would decrease to 50.06 feet, which exceeds the minimum 25 feet for frontage, so that's okay. There is a requirement there be an access easement for flag lots, which I think Attorney Polidoro just want to see a copy of that. I see it's shown on the map, but if there's a copy of the easement for her to look at, that would be helpful.
The one we're creating, or the one that exists?
Well,
Or both?
I think we'll talk about both in a minute.
Okay.
I'll defer to the attorney on that. So the only thing that I'm not clear about, maybe you can help, is the width of the lot on 921. Would the width be meeting the 300-foot minimum width? Because if it
So
wouldn't
my
be,
question was, when I read this
Yeah.
comment also, was that is the frontage and the width, so I
They're
brought up
different.
the bulk table, and there's no
Yeah.
width on the dimensional table.
Okay.
Listed, and I looked all through, and I couldn't figure out where that 300 feet came from.
Making
So
a
there is a
flag lot
300-foot
requirement.
frontage.
I think it's a flag lot requirement in.
Yeah, I looked through all
Which is
the
where you
flag
measure
lot.
it, right?
Yeah,
Usually it's the width at the building line.
yeah,
The
that's
flag
how it's
lots.
defined in if you go to width and definitions.
Is it 145.22?
There's also an argument to be made that both these lots are actually rear/flag lots already.
Well, I'm looking at. Sorry, I think I found the answer. Wait, well, maybe 145.22C.
Except as indicated in subsections A and B above, rear lots must meet all other requirements for a lot in the applicable land use district. Minimum lot width shall be the same dimension as the minimum road frontage otherwise required in the land use district.
That's where it is.
Okay.
So that's 300 feet for the RU.
That would be at the building line.
Yeah. So that's the question.
That's
Is
why I was kind of, is it the same kind of?
the frontage is? I mean, you're going from like 25. You're, like I said in the comment, you're still over 25 feet on the frontage, so you're fine there. It's just that the minimum width becomes what the frontage requirement is for the district, which is 300 feet. So that's the question. If you can meet that, you're okay. If you can't,
So would
looks
that
like
mean
it's there.
the 917 is substandard as well?
I don't think there was an issue with
But
917.
that's not 300 either.
Hmm.
So they're both 250 feet wide at the buildings. Well, actually not at the buildings really. At the one on 921, it's 250 feet wide. 917, they actually have the house inside. I would call it the flagpole access strip.
Yeah, that one's a little.
Yeah, I mean, you're increasing the frontage of 917 to 260
Yeah.
feet from
I guess
155.
my argument kind of would be
Yeah.
when they did this in '93, the code might not have been the same, but I think you can almost argue that right now you have two rear lots. There's no definition on the maximum access strip, so but it's substandard on both, it being 155. So could it already be, non-conforming existing?
Did you pull the filed map?
Yes.
And what does it say on it?
As far as,
Does it say how it was approved?
1993, I used it for my survey, I don't have it with me.
All right, let me see if I can.
I mean, they're both considered pre-existing non-conforming, I think.
Yeah,
But-
since I'm not changing the width per se, at the
I think
house
are
lines,
the tax parcel numbers wrong on the application?
I have it wrong on the,
Okay,
It
'cause
should
I'm
be a
trying to
9
find
instead of a
these and
6
it's
on the
not,
one.
they're not
I-
coming up.
yeah, it's changed to 6 for a 9.
Okay,
Okay, sorry.
so let me pull up the old file map.
So you're not changing the width on either of the lots.
No,
So,
I'm changing the frontage on
one,
the one,
so it's turning it into a flag lot though.
Yeah.
but isn't the, I don't know, that's my kind of where I'm.
I mean, the current road frontage for both lots is, I think I just saw 155, is that what I saw?
which is
Which is
not,
substandard.
not meeting standard. Yeah, it's 300 feet is
So
the
wouldn't
requirement.
that be the
But you're-
155?
I mean, it was
is the
subdivided
access
by
strip?
this planning board at some point,
Mm-hmm.
under their rules at that point. I mean, I don't know.
Yeah, that's what I mean, 93, who knows?
It's the same rules.
Turned into a flag lot.
As part of this proposal.
I think
So
that,
the definition
I
where
think you
the
can say
width
they're both
is
flag
changed.
lots.
But again, the
Right.
width of the lot?
Yes.
So is,
Must have been a different zone law at the time.
yeah, of course. So do you take the width of what was approved at that time or the new width?
Well, the lots as they exist are what's approved. You just can't create a new nonconformity. So the question is, by narrowing it in the front and the back, does it change that dimension?
No, you're not changing the dimension on the building, no. Just look where the building is. The building width is not changing
Yeah.
at all.
And you're not
We're
worsening-
bettering the one, as you
Yes.
mentioned,
Well, that's,
but we're
I mean,
not making,
when
I
talk
don't
about
think,
changing, you mean negative.
yeah,
Right.
I don't think we're making another one.
No, it looks from there.
Yeah, if the width is 260 or 250
Well, I
more or
think
less
it's
for
because
both,
of
then
the
that's not changing.
Oh,
I
yes, sir,
guess
please just speak
for
at the microphone.
pre-existing
so
Oh,
I can
sorry.
hear you. That's okay.
Sorry.
The width is pre-existing
Thank you.
non-conforming, I guess.
Yeah,
It sounds like.
So it's already pre-existing non-conforming?
Yeah.
yeah.
And it just would still be the same width? Because that's not
One
changing.
stays the same, the other one actually decreases.
Gets
in
better.
conformity.
Right.
On the frontage.
And
But the-
even in the width, because he's gaining more width.
That's
on it.
true.
So the width in the road frontage is increasing on the southern one.
Mhm.
The northern one, the width, which would be the code, because it's now a flag lot, stays the same and has no change.
And the flag, narrow portion is complying. So,
the
I'm saying it's
nonconformity-
somewhere around 250 feet?
They're,
so the
yeah, they're exactly the
nonconformity
same too.
just stays the same for one, and the other one decreases.
Right, because the other one then is really going from then, what, here to
Well,
almost
actually, you would take it
somewhere.
from the front of the house, so it may actually be from the
Yeah.
corner.
So from that corner?
Yeah,
That
Yeah.
corner.
technically,
It's even narrower.
otherwise you'd meet it.
But it goes out to somewhere over
Yeah.
here.
So it's increasing.
but it's growing, so it's not
Right.
worsening the
200
non-conformity.
feet,
So
give or
it's
take.
lessening the nonconformity, which is what it is.
Yeah,
You
so I
want-
guess
Good
we
thing.
were good.
You just need that stated in the bulk table, so
Yeah.
it's clear.
Just make it.
Yeah, I'll update all that. All of it.
The minimum lot depth used to be 150 feet, and the width for dwellings was 20, well, that's the building width. But it looks like it did comply with the R40
Yeah.
when there was an R40.
And it'd
Right.
be non-conforming at some
Might be
point.
155 instead of the minimum
Okay.
being
So
150.
the changes here will not decrease.
Shouldn't need a
any
variance.
nonconformity.
So ZBA is probably not an issue, and you probably don't need to refer to the county.
Just state all that on there, so.
Well, it's
that-
got to refer to the county because it's along a county road.
No, but we don't
Not,
refer
not for a
subdivisions.
lot line change, unless there's a variance involved. Yeah.
Put all
But
that on the
where's
bulk
that coming
table,
from,
so
like
that
variance? Is that
all
new?
this is
Yeah, it'll be-
documented.
No, it was,
Crystal clear.
You don't have to
we've been
revisit
using
it.
that comment
Yeah.
for a while about the county
Bigger,
doesn't
just one
do
big bulk table.
subdivisions unless there's variance.
Yes, you got it.
Even with a variance, I've never heard.
We did it. Yeah, we had that in there for a while. Those are other.
All right, so where
other
are we
ones.
with this now? Go to the
Yeah.
county or not?
No,
Okay.
No
Doesn't-
county, no ZBA?
no county, no. It's, again, yeah, just respond to these and
Mhm.
to be confirmed, but it looks like no for that.
What number are we on?
11,
Zoning table should be updated.
yep, zoning table, which we talked about. Oh, just we noticed that the bearings and distances for the new lot lines weren't fully completed on there. If
I
you could
see.
just update
Yeah.
those, that's a requirement on the code, so. And then 13 is just about possible waivers that the planning board can grant, for a lot line change. You don't really need to see all these things that you usually call out on a subdivision, like the trees 8 inches in diameter, large rock outcroppings, wetlands, et cetera. And I think the applicant has already requested a waiver for these, so I think that's appropriate. Permission to file is required on the final plat, and it's a type 2 for seeker, granting of individual setback and lot line variances. And 16 is just noting that there are flags in the EAF mapper, and when that's the case, we usually just have a note on the plan saying that, disclosing the potential for these species, source DEC. And no wetlands or watercourse issues to deal with on this one. So recommendations would be to type 2 and set a public hearing, I guess. Because there's no referrals needed. So assuming the applicant can respond in a timely fashion, you could have the public hearing set for next meeting.
Okay.
I can do 9 days.
You can do 9 days. You've been paying attention to the last. Thank you.
The only one in here.
All right. So then the
And we'll update the memo for next time to.
Well, I have just a few things before we go to.
yeah, I'm just saying the resolution is only about secret.
It's just classified as type 2.
Right. I'm saying there's nothing else. We don't have to change because of the changing discussion we had about this. There's nothing has to be taken out or added. Or, okay.
No.
All right. Very well.
So there, if you go back to the subdivision plat, per filed map 8615B, there is a driveway location and easement.
Sorry, the subdivision.
Yeah, if you zoom in, you can see that dotted line.
Yeah, it goes through the house.
Yeah, this one actually does go
Yeah.
through the house. And so, that is a blemish on title, and if you're going to sell that lot, I mean, Mr. Johnson and I just went through something similar. You can't have something like this.
What's this dotted line supposed to be?
It's an easement to the other lot,
Ah.
This one?
and you can't just extinguish an easement on a filed map. You actually have to amend the filed map to remove it. So I think it would be prudent to take this opportunity to also style this as an amendment to filed map 8615B to remove that driveway easement because you have a house there and otherwise when he goes to sell it, he can go fight that next person and,
Right.
you know.
It's going to be a lot line realignment, gets filed anyway,
And what does-
permission to file anyway.
Yeah.
So it's going to be listed as a modified map down at the county clerks anyway. It's the same number with a B or a C.
Yeah, it'll be a C.
So just put all the stuff in there.
So are we thinking that originally the houses were supposed to be like back here?
I think.
So that's why the driveway's like this, so one house would be here, the other house would be somewhere over there?
Yeah,
Like, is that
Yeah,
probably
I think
what?
someone did this plan without actually going out there.
Yeah.
So, I mean,
And then they just-
the old map is available and there's no house location shown on it.
Right.
So I don't know how they decided where it was going to go. But there is another note as well that says. No. Driveway entrance to be constructed in accordance with Dutchess County Highway Department. The access location is acceptable for only the 2 lots shown, not to any further re-subdivision. Applicant is required to post a sign at the driveway entrance prohibiting left-hand turns out of the driveway. So I don't know if that was ever happened, if it's something you still want carried over. I don't know if we need to have the County Department of Public Works approve this.
That note is not relevant to the county anyway, because no permit was ever issued.
Well, maybe, because that's an existing driveway now, right? So
Yeah.
I don't know if they were supposed to be complying with this note, so either the
There
note,
was a sign there, this is like the fence thing from the center, maybe there was a sign there and it fell down and no one gave it
I don't recall a sign.
crap.
so
It's an existing driveway.
this note, though, is part of what needs to be carried over.
We can keep the note on there.
Probably because of
Site distance
crossing
or something?
traffic.
Yeah,
And there's site
If I remember where this is, I don't
All
think that's
notes
an
and
issue.
conditions on the original subdivision
pretty
map
much
are
guaranteed
followed,
what it is.
And that way you cover.
Put a mirror up.
fine.
You follow, it's a standard, all notes
I
and
mean-
conditions approved on file map XXX shall be complied with.
Guarantee you people make lefts out of
Oh,
there
yeah.
all the time.
Sure.
So you also want the
Make it to 10.
extinguishment of that
Exactly.
easement on that map.
Well, yeah, I mean, I think
That's easy
that's
to
the
do.
time for them to do it, and then we need to create a new easement with meets and bounds in the location where it is.
Get
I
rid
agree,
of
it's
that?
easy to do.
Oh, yeah.
Do we need to get rid of, we're having too many conversations here. Do we need to get rid of the
That
no left
note?
turn sign? I mean,
So that would be something the applicant might want to do, and we would need something from county approving that, so we could also amend the plat to get rid of that note.
Right.
So to delete the special driveway entrance note, but obviously there was thought through some discussion about it
Yeah.
at the time.
I think that would be complicated with the county highway.
Well, otherwise the note has to carry over.
I mean, there is some crest.
Just carry the note.
There is some cresting of a hill that does take place somewhere in that, what we're looking at right now. I just don't remember exactly where.
I mean, I just want to say there might be liability on someone's, if someone gets in an accident and there isn't a no left turn sign, there's not liability for the planning board, but for that homeowner, that could come up
Sure.
later, so.
Yeah.
But better is to
I mean-
carry the notes over, I think.
It would carry over to the current homeowner, not the person who subdivided and put the driveway in.
I don't know if I was, those
Well, I mean,
personal injury
everybody
attorneys.
sees everybody,
You're not
right?
a
So-
Yeah, Lauren.
We'll just carry over all the notes, and if he's got to put a sign up, he'll put a sign up.
Or call county and see if you can
Yeah.
get permission to remove this note. But I think it's time to clean all that up. And then, so we want meets and bounds for the new driveway easement
Yep,
location.
it should be on there, actually.
Oh, okay.
And then,
Yeah,
we'll
I
have-
really do feel like in driving that road for the last 20-plus years, I would have noticed a no left-hand turn sign. Some random location. I guess.
Yeah. And then, we'll need to see the actual easement document at some point.
Yeah, he'll have his attorney draw it up.
Okay.
So the existing driveway stays?
Yeah, there's no proposal to move the driveway.
I mean, it's kind of silly if they're taking that land to have the driveway go right through the middle of it, but.
Well, it probably goes where it goes now, just so that it's
You're not building any new roads.
a shared burden for both houses.
Right, but I mean, once he moves
Oh, I
that
get
lot
that,
line, it's
yeah.
just like, it makes this
Right.
kind of.
Maybe then
unusual.
that other driveway easement makes sense.
Yeah, but not through the house.
No, probably not. Unless you want,
Well, the easement, if
Build a
you create
tunnel.
the flag rear lot for 921, there's no sense for an easement because he has a driveway.
no, he already has a
His
driveway,
property.
yes.
He was debating building a driveway, but the cost and,
Sure,
yeah.
yeah.
Can you actually put a driveway where the
I think
easement
it'll
is?
take a little bit, but he could probably.
I mean, it's,
Yeah.
Why?
I've
sloped
seen
for-
driveways go in places I never thought driveways could go, so.
so then I think you guys just need to tell us whether you're creating a shared driveway
Yeah.
over the current one, or whether it's just that shared entranceway, because that would be a much smaller easement.
For this application, we're doing shared
Okay,
driveway. So,
in the existing asphalt
You're
drive
just-
location.
the one
Turning
that-
over
it's on the
much,
map.
you're just turning over almost all the ownership of it to the southern parcel.
Yeah, 917, yeah.
Don't they have to have some kind of agreement?
Yeah, it'll be drawn up.
Yeah, we need an easement and
Maybe
maintenance
it's all
agreement.
fine.
And it says 15 feet wide, but shouldn't it be 20?
It
Or
calls for
driveway?
Existing.
15 in the code. I can make it 20,
NFPA.
Well, not the drive, but I mean
the
the
easement.
Oh.
Well, the
easement
easement
area
should be 20 feet, yes.
on either side, because it has to have curb,
Mm-hmm.
And it should be for utilities as well.
Yeah. Well, you want to comply with NFPA 13, which says the 20-foot control doesn't have to be paid.
Right.
That's why you do the 20 feet. That way the easement has control.
Change the code.
Well, the drive itself can be less.
Yeah, I know.
Okay, so,
Even with all these changes, it's still going to be type 2 action.
Right.
So,
all right, so we have a resolution to classify the action. Members of the planning board have any comments, questions before we get to this? No? Resolution to classify the action, Petrie lot line alteration. Whereas the applicant, John Petrie, has submitted an application for approval of a minor subdivision plat to alter the lot lines of two existing lots to convey approximately 3.658 acres to Lot 1, identified as parcel number 6959-00-966655, and add it to Lot 2, identified as parcel number 6959-00-957630 in the RU zoning district, known as the project site, and whereas the project is shown on a site plan entitled Lot line alteration prepared for Petrie, prepared by Johnson Surveying, dated December 28, 2025, sheet 1 of 1, the subdivision plat, and whereas the applicant has submitted a short environmental assessment form, or EAF, dated January 7, 2026, pursuant to the State Environmental Quality Review Act, or SECRA, and whereas no new development is proposed on Lot 1 or 2 as part of the project, and whereas in accordance with SECRA, the planning board is required to determine the classification of the project, and whereas pursuant to 6 NYCRR Section 617.5C, subsection 16, a lot line adjustment is a type 2 action under SECRA. Now therefore be it resolved that the planning board hereby classifies that the project as a type 2 action. The planning board hereby classifies the project
Oh, yeah, thank you.
as a type 2 SECRA action. This resolution is being offered by
So move.
Member Volano,
Second.
second by Member Little Bedier. Discussion?
Eight's wrong.
Yes.
Okay, let me just make sure I say this other one first.
Should say the second.
February 6th, right?
February 6th, yeah.
Just gonna repeat this again. It's Groundhog's Day.
Okay. Any further discussion? Debate? Okay, seeing no further discussion, resolution to classify the action, Petrie lot line alteration. Secretary, please call the roll.
Member Williams.
Aye.
Member Volano.
Aye.
Member Sador.
Aye.
Member Palmer.
Aye.
Member LaRobidier.
Aye.
Chairman Courtine.
Aye. Resolution is adopted 6-0 with no abstentions, 6-0. So, anything further for this application this evening?
Public hearing.
Oh, yeah, please.
Well, oh, okay. You think you get all that done?
You said you can get
Yeah, you
done.
said you could do it within 9 days, right?
Oh, yeah,
Yeah.
sure.
So, motion to set a public hearing
So moved.
for March 2nd. 7 p.m. or soon thereafter, as the
4:30.
planning board could be holding this public hearing. Motion made by Member Sador, seconded by Member Palmer. Discussion? Seeing no discussion, all those in favor say aye.
Aye.
Any opposed say no. Motion passes 6-0. Anything further for the Petrie lot line alteration?
Okay.
Thank you.
See you next month.
All right. All right. Before we just get to the end here, the Secretary Van Millen has circulated the proposed
We have
Chapter
the
145 changes.
release of the bond for TMR.
Okay. We can do that. So to finish what I was saying, please review Section 145 proposed changes. I believe the town clerk would like to have anyone's suggestions by sometime in mid-March. I think there was an exact date, but
March 13th.
March 13th. Okay.
It'll be, and if you want, you can send them also to me, and then I'll forward them to her.
I am going to have a conversation with the town supervisor regarding whether the town board wants our consultants to look at the proposed zoning.
They received it also.
Yes, but there's nothing in the budget for them to review the town zoning, so it becomes an expense to the town.
Well, the town board, at the town board meeting, authorized us to send it to the consultants.
Okay,
Okay.
so if that's what they did, great.
Okay.
We have it arranged with, there's a retainer that we have.
Well, you're part of, yeah, it's
And for either,
Attorney Polidoro is not
right,
a town board attorney, so.
exactly, right. So we could work, we'll try to work within that budget for our comments, but
But you can check with Rich.
Yep. All right. So the last thing we have was TMR resolution. Resolution recommending the release of the performance guarantee 10 Mile River Preserve Activity Barn Whereas on October 7, 2024, the applicant 10 Mile River Farm LLC received site plan, special use permit, and architectural review board approval to convert an existing barn complex into a quote-unquote activity barn, including outdoor patios, 21-space gravel parking lot, and an overnight guest unit, collectively known as a project identified as 280-290 Sand Hill Road, tax lot number 7162-00-048775, known as the property. And whereas the property is located in the RU district as well as in the floodplain and aquifer overlay districts, and whereas a recreational business is a permitted use in the RU district subject to site plan and special permit approval, and whereas as a condition of approval of the erosion sediment control permit approved on October 6, 2025, the applicant was required to submit a performance bond guarantee in the amount of $1,500, and whereas the planning board engineer has conducted a final inspection of the project site and by letter dated January 22nd, 2026, has confirmed that all work authorized under the erosion sediment control permit has been completed and all provisions of the permit have been met. And whereas pursuant to Town Code Section 65-11, subsection C, such performance guarantee shall continue in full force and effect until a certificate of compliance shall have been issued by the authorized official after such consultation with any agency or individuals as he deems necessary to ensure that all provisions of this chapter and of the permit have been met. Now therefore be it resolved, pursuant to Town Code Section 65-11, subsection C, the Town of Dover Planning Board hereby recommends issuance of a certificate of compliance and the subsequent release of the performance guarantee submitted to the town by the applicant. This resolution is being offered by Member Palmer, seconded by Member Williams. Discussion. We're all set there? Okay.
Yep, they did everything.
Any further discussion? Seeing no further discussion, resolution recommending the release of the performance guarantee, 10 Mile River Preserve Activity Barn. Secretary, please call the roll.
Member Williams?
Aye.
Member Valano?
Aye.
Member Sador?
Aye.
Member Palmer?
Aye.
Member LaRobertier?
Aye.
Chairman Courtine.
Aye, this resolution is passed 6-0. All right. Our next meeting is March 2nd, 4 weeks from tonight, with a deadline of February 11th, and then there is a meeting on March 16th with a deadline of February 25th. And then we have meetings planned for April 6th and April 20th, provided that we actually have business those dates. Any further business before this planning board? I'll make a motion to adjourn, seconded by
Second.
Delano. All those in favor of adjourn say aye.
Aye.
Aye. We're adjourned.